Good day, Internet. Chavez and Valco here, the key to your immigration solutions. I'm Senior Associate Ben Hamilton. With me, as always, is Associate Attorney Andrew Craven. Andrew, how you doing on this gloomy and wet day here in Dallas, Texas?
Doing good, Ben. How are you?
I am doing right. I think I am sufficiently caffeinated. Here we are talking about a recent settlement, and it is not the Facebook settlement. We talked about that in a previous video. Look it up if you're interested. Actually, today we're talking about a government settlement where the USCIS just settled a class action lawsuit involving H-1Bs and a specific position, and that is the position of market research analysts. So, Andrew, um, we got to provide a little bit of background here in terms of kind of what's going on. So, H-1Bs are for positions that are qualify as a specialty occupation. What is that?
So, the definition in the regulations is that it requires a theoretical and practical application of a body of highly specialized knowledge and the attainment of a bachelor's or higher degree in the specific specialty or its equivalent is a minimum for entry into that occupation in the US.
The key here is it says an attainment of a bachelor's or higher. So first, they're kind of setting that threshold. The position has to require a bachelor's, but it's more than just a bachelor's. It says in a specific specialty. So you can sometimes run into an issue where a position clearly requires a bachelor's, but not a specific bachelor's. So it can kind of hit you on two different issues here. Does the position require a bachelor's? And if it does it require a specific bachelor's? Or actually, the way that they should correctly frame it is more of a specific set of education rather than focusing exclusively on the degree. So the regulations have laid out sort of four different criteria to qualify as a specialty occupation. So if you meet one of these four, you qualify. But at issue here is the first of the four criteria. So we're just going to focus on that. So, Andrew, what is the first criteria to qualify as a specialty occupation?
So a bachelor's or higher degree or its equivalent is normally the minimum requirement for entry into a particular position.
And I like your emphasis on the word normally. So basically, if you can prove that it's the minimum requirement, sort of like an industry standard, right? That it's normally the minimum requirement. The other criteria, are a little bit more focused on the specific position. Like, does the employer normally require a degree? Is the job so complex that it requires a degree? So they're really looking at the job description, or can you prove that it's sort of common in parallel positions among similar organizations? That's where you start looking at your competitors and being like, well, look, my competitors require a degree for the same position. So obviously it makes sense. But the first prong is just, is it kind of like an industry standard? And Andrew, throw this one out here. What is the legal standard when you're talking about, visa applications? Is it, beyond a reasonable doubt?
So it's for immigration, it's generally preponderance of the evidence. So more than 50%.
So it's more likely than not, or 50% plus a fraction, which lines up with what the requirement says. The requirement says normally. Normally is not absolute. It's not 100%. It's not must. It's just normally. And you're going to find that a lot of this lawsuit and settlement kind of evolves around the words here. So what is what so when the USCIS is looking at a position to determine whether it normally requires a degree, what are they looking at? What's their sort of main resource?
So the main resource would be things like ONET or the Occupational Outlook Handbook or the OOH.
And the OOH is from the Department of Labor. If you just Google it, you'll find it. It's right there. And so you can look up any position you want. within the OOH. And you'll see that there's tabs for what do they do, work environment, how to become one, pay. In this case, the tab of how to become one is critical. So we're going to provide, we're going to look at market research analysts, but also provide another similar example, right? So for market research analysts, the OOH says the following: market research analysts typically need a bachelor's degree in market research or a related business, communications, or social science field. Others have a background in business administration or social science. So, two things we're going to notice here. One is that it says typically need a bachelor's. So it doesn't say must or always. It just says typically. The second one is it does mention multiple fields of study, maybe kind of implying that, hey, it's not that specific because it says market research or related business communications or social field. Others have backgrounds in business administration or social science, right? Seems a little open-ended, which can be problematic. So, Andrew, what's been our sort of um, what's been our problem in the past? How has USCIS, I would say, misconstrued the word typically?
So generally, they'll say that words like typically are not saying a must or that it definitely requires it, and try and play that off in their request for evidence as not being the normal requirements, trying to say that typically and normally are two different of words.
Yeah, I mean, they're basically saying that you must you must show that the position must require a bachelor's, right? Which is like, well, that's not this that that's not what the rule said. It says normally, and must are not the same thing, right? And that's not the evidentiary standard. The evidentiary standard is preponderance of the evidence. And so you feel sometimes like, what is going on here? You're basically asking me to prove that the position 100% of the time requires a degree when that's not the legal standard. Even when sometimes there's evidence like from ONET where they collect data on like what percentage of employers require a degree. And sometimes you can have a position where ONET says 90% of employers require a degree, which in my mind meets the normally standard, but then they'll come back and act as if, well, how do we know you're not in the 10%? And you're like, well, that's not the standard. I don't have to show 100%. I only have to show, 50 plus a fraction. And just to give you an example, this is actually a really common issue with H-1B. In fact, I would say that the majority of H-1B positions kind of fall into this similar field. As an example, one of the most common H-1B positions is a software developer. And if we look at software developers, this is what the OOH says. Software developers, quality assurance analysts, and testers typically need a bachelor's degree in computer information technology or a related field, such as engineering or mathematics. So it kind of runs afoul of the same problem. It uses the word typically, right? And it kind of starts off specific with computer and information technology or related field, and then such as engineering or mathematics. And then so it seems to kind of suddenly veer into more vague territory. I actually want to throw up a another example here of a position whereby you actually wouldn't get challenged along these lines, and that would be a civil engineer. I'm going to bring that up here in just a second. I should have had it handy. How to become one. Here we go. Here, it says civil engineers need a bachelor's degree, right? So if your position is civil engineer, you're never going to get questioned, right? It says need, right? That's basically an absolute, like 100%, right? And it says they needed a bachelor's degree in civil engineering technologies, or related fields such as construction. So it's also fairly specific, right? So stuff like a doctor, a lawyer, a dentist, a civil engineer, those type of fields, you're typically not going to run into one of these challenges, right? Because it's kind of an absolute that you have to have a bachelor's degree, and in a fairly specific field. Um, so, what were the parties here arguing? By the way, I got to find the name here. It's The case is called MadKudu Inc. versus USCIS. MadKudu Inc. MadKudu Inc. is actually a company in the Bay Area that had a position for a research analyst denied, market research denied. They sued, but then they turned it into a class action lawsuit, arguing that tons of market research analyst positions were getting denied for the same reasons. Going down to the complaint, right? Again, we're running into two issues. Does the position normally require a degree, and is that degree specific? So here's kind of what the typical thing you hear from OOH, and I'm sure from USCIS. I'm sure a lot of you who have filed an H have seen this in an RFE or a denial. And this is what USCIS says. The OOH indicates that several degrees or fields for study may qualify a person to perform duties of a market research analyst. Right? This is they're saying that it's not specific enough. And then the complaint. This is a quote from the complaint. Multiple degrees will prepare a person to be a market research analyst does not negate the fact that typical degrees for this position are closely related to market research and thus constitute a specific specialty. So we see this in a lot of different fields. Andrew, who is the actual class here? Meaning USCIS has come to a settlement whereby they will allow affected parties to reopen their cases. Who is the class?
So a couple of requirements here. First, the H-1B petition has to be filed on or after January 1st, 2019. Then USCIS found that the job fell within the market research analyst occupation. USCIS considered the OOH entry for market research analyst. And then the last two, USCIS found that the market research analyst occupation was not a specialty occupation under the first regulatory criteria. And finally, the sole basis for the denial was that the position was not within the specialty occupation.
Obviously, it's pretty specific, right? You had to be denied as a market research analyst under the first prong. We said those are 4 criteria under that first prong, and it had to have been after January 1st, 2019. So obviously this is limited, although the analysis could be applied to tons of different job codes. This settlement is limited to market research analysts. So again, what are some of the things that USCIS agreed to? Let's see here. There are about 4 general agreements in the settlement. So the OOH entry for market research analysts demonstrates that a bachelor's or higher degree in a specific specialty is normally required to enter the occupation. So first and foremost, they're accepting that the OOH supports the first prong. Hey, the OOH says typically is the same as normally. I don't know why we have to explain this to USCIS again and again and again. I've done it in so many RFEs where they're like, you haven't proven that it normally requires. Typically, normally, usually, they're all the same words and they all exceed preponderance of the evidence. Like, do you guys not have a dictionary? Or can you not Google the word? Ask Siri, ask Google, right? Ask Alexa. They'll tell you what these words mean and that they're all similar. But they also agreed to the specific degree requirement, because this actually comes back to, if we go look at the OOH, they love to just kind of bury their head in the sand, right? And they love to just say, well, look, it says you need a bachelor's degree in market research or related business, communications, or social science field. Others have background in business administration or social science. So they're saying, well, that's too broad. That's not a specific specialty because there's a bunch of different degrees. Here's the problem. USCIS completely failed to read the next freaking line in the OOH. Sorry, but this is so frustrating that we have to deal with this all the time. What's the next line say? Courses in statistics, research methods, and marketing are essential for these workers. So while the degree may be a little bit broader, the core education is specific and can be found in multiple different degrees. And that's the argument that the plaintiffs made in this case, is to say it's not about the degree, it's about the education. So one of the things that they agreed to in the settlement is that a bachelor's or higher degree in business administration with an official minor, major, concentration, or specialization in market research, marketing, or research message is not a generalized degree. So again, if I have a degree in business administration, they just automatically like, well, that's too generalized. Well, yeah, but what if I have most business administration degrees have a concentration in something, finance, accounting, marketing. So they're basically admitting that, hey, where I have what can appear to be a generalized degree, but with a corresponding concentration, that's okay. I don't know why we have to explain this to them. That if I have a business administration degree with a concentration in market research, that should be obvious. The third one is that a market research analyst position that accepts a bachelor's or higher degree in communications, statistics, computer information technology, and or social science may qualify as a specialty occupation if the petitioner is able to demonstrate that an official minor, major concentration or specialization in market research, marketing, or research methods is necessary to perform the job duties. Again, coming back to don't just look at the degree, look at the actual education. This is why sometimes we submit transcripts and we point stuff out. And we say, look, they took degrees. Although this may be a degree in A, they took classes and it was part of their curriculum to take classes in market research or marketing or these things. And then the fourth one, USCIS must issue a request for evidence and not deny a petition outright. So if USCIS going forward has any questions about a market research analyst, hey, we got to they must issue an RFE and can't deny it outright. Now, there are some caveats in the settlement. Andrew, what are some of our caveats?
So main one, USCIS will still adjudicate each petition on a case-by-case basis. Evidence that the petitioner would consider someone with less than a bachelor's degree in a specialized field directly related to the position can also sink the case. Um, And then lastly, the burden is still on the petitioner to establish eligibility by a preponderance of the evidence. So you basically don't get an automatic win just because it was a market research analyst. You still have to go through all the usual steps.
So for example, you can see an RFE where they say, well, we want to know, we want the names and educations of everyone else in your company that holds the same position. And if they see that you hired some people into that position that were probably U.S. citizens or residents that didn't have a corresponding degree, because that's really common, right? You may find someone that doesn't have the corresponding degree but has like experience, and you hire them based on experience, not the degree. So you can see where they're looking at your company, it's your hiring practices. Who else do you have there? And also, I mean, I've seen this happen a number of times. I remember this happened. We had this happen in a case involving a Montessori teacher where we're like, do you require a degree for all your teachers? Yes. Great. Let's see them all. And they showed us all the degrees, and they had degrees just all over the place. Just all over the place. And we're like, well, we can't argue we require a specific degree when you have someone over here with a degree in history and someone over here with a degree in economics and someone over here with a degree in childhood education, which corresponds. But it's like, so they can still, submit an RFE and challenge you to see if whether or not you truly do require a bachelor's, and if you do that, you truly require a specific, line of education to back it up. So, getting into, so you still have to be able to prove the points of your case. I'm not just going to accept it automatically. Getting into the, here, we're going to skip here just a little bit. So, what are the next steps for the class? So, if you're a class member, right, you're saying, hey, we submitted an H-1B for a market research analyst. They were denied. It was since January 1st, 2019. What do I do?
So first, you have 180 days to file a motion to reopen, and that's going to be Form I-290B. Also, class members don't have to pay the filing fee. Presumably, just because you've already submitted it, you already paid the filing fee, and this was USCIS error. The motion must include cover letter, the receipt number, a confirmation that the job offer remains valid, and verify the start and end date as long as it's within the original LCA period. And then finally, the motion must also include a copy of the original USCIS denial.
Yeah, the cover letter's key because you got to remember, you got to get through the mailroom, and sometimes just getting through the mailroom is extremely difficult. I don't know who they're hiring or how they're training them, but man, I can tell you the mailroom is a headache of getting things erroneously rejected. So that's why it's really important to, like, if you're a class member, you need to put like a brightly colored sheet on the top that says, like, you know, settlement class member, like big bright letters, because otherwise they're just going to immediately reject you for not having a filing fee attached. So you want to make sure your case doesn't get rejected. I also love how, like, you specifically, they're like, hey, in your motion, you need to include a copy of the denial. And it's like, you denied me. Like, why don't you? Why does USCIS routinely request us to send stuff to them that their own agency adjudicated and issued? It doesn't make any sense. It's like, yeah, I don't know. It'd be kind of like you submit your tax returns and then later you're getting audited and the IRS is asking you for your tax returns and you're like, you have them. We submitted them all to you. Um, yeah. Anyway, so again, 180 days. That's kind of the key. One of the issues you're going to run into is you're going to have someone who, like, the job, like, they didn't get the H and then they left, they're gone, right? And so the job offer has to remain open. So, like, if you uh, did an H cap case and, like, I don't know, you were on STEM OPT, meaning you're actually still working there because you're still on your OPT, then this is going to be great. Um, if you left that company, you would have to go back to them and convince them to open it and then take you back. Now, we get into the key question here. Why did USCIS settle? Right? Why did they do this? Andrew, what's the short version? Why did they settle?
Probably because they realized they were going to lose.
As we've already mentioned, the majority of H-1B petitions, I would say, involve a category where the words are typically, usually. Um, and again, we're talking about a lot of the IT fields. So if you were to actually fight this out in court, I think they saw the writing on the wall. They were going to lose. And obviously, if the court issues a decision and specifically addresses the language, there's obviously the implication that that decision would be then applicable to any category, any position that uses the same language. Meaning USCIS was like, oh man, if this goes against us, we've just lost, you know, our best quiver, our best arrow in our quiver, right? That we're going to be completely kneecapped. Our ability to really challenge these cases is going to be, um, is really going to be hobbled, right? And so in this case, well, hey, if we settle, we're going to have to cave on market research analysts, but we can still challenge everybody else. Of course, what we're going to need here is just more of these types of lawsuits, right? And so I do want to give a shout out to a lot of the people involved here, um, including the American Immigration Council, the American Immigration Lawyers Association, or AILA, Jeff Joseph, Charles Cook, and others, and their respective teams, because these are people that have been involved in a lot of federal litigation, especially class action lawsuits. They've done some really good work in terms of challenging the agencies and forcing them to um, do the right thing, forcing them to understand basic English, that when the law says normally, that is not an absolute, that is not 100%, right? And that when the OOH says words like typically and usually, that's kind of the same as normally. Um, so that you shouldn't be, hopefully going forward, although you can't really cite to this settlement for a different category. You can't say, well, I'm a software developer, look at this settlement, right? Um, at least it gives us, you can read the complaint and definitely sort of reuse a lot of that, the language and the arguments going forward to fight USCIS on these cases, potentially threaten litigation. And then if not, look to put together actually sue and put together a class. And again, I can see this um, in a number of different categories, not just market research analysts. Again, I mean, software developers uses the same language, and that's a huge category. Um, Andrew, any final thoughts on this settlement.
I think the big thing to remember is the 180-day time frame. So if this does affect you, just move quickly to do what you can.
And just remember, hey, if you guys have any questions about your case, reach out to us, right? Online, you can go to our website, schedule a consultation on the different social media, right? We're always here to sort of meet with you, discuss your case, see if you qualify as part of this class, file the motion to reopen. Also discuss potential RFEs and denials and similarly situated, H-1B positions at all times. Also remember, we have a great app, Lawpilot GUARDIAN, that you can download for free. It has a lot of good information about knowing your rights, also immigration updates. Also, for any of you attorneys out there that may be watching this, you're interested in about this settlement, we do have the Law Pilot software. It's actually our own case management software that we're actively developing. It's a great sort of comprehensive case management software designed by a immigration law firm for immigration lawyers. We're not fancy developers, although we had to hire some to help us. But we are an actual immigration law firm developing our own case management software that we then obviously want to put out there and share with other immigration attorneys, right, to help you organize your practice, increase your efficiency, and then hopefully do it in a way that makes sense to immigration lawyers. So again, any questions, reach out to us. We're here. Download the app, go to our website. Also check in to Lawpilot, the case management software. But until then, hey, we'll be back with immigration updates, also continuing our series of immigration videos. Now we're going to start into about all of the employment-based residency categories. So obviously we've been talking about non-immigrant visas up till now. Now we're going to start talking about residency options via employment. But Andrew, thank you. And to all those that tune in and watch this video, thank you. And we'll see you later.